Something is actively happening inside United States immigration offices right now that the overwhelming majority of green card holders and visa applicants traveling internationally have absolutely no idea about. And if you have traveled back to your home country even once in the last 3 years, if you are currently planning a trip for a wedding, a funeral, a family emergency, or simply to embrace your mother after years apart, you need to stop everything you are doing and give this your complete undivided attention right now, because what we are about to cover has direct and serious consequences for your green card approval timeline, your adjustment of status application, your naturalization eligibility, and in certain situations, your permanent legal bar from ever re-entering the United States again. This is not fear circulating through WhatsApp family groups. This is not speculation from social media comment sections. This is grounded in real documented immigration enforcement patterns and concrete regulatory developments that are actively destroying real cases every single day in 2026. And if you close this video before it finishes, you may walk away permanently missing the single piece of information that is most directly relevant to your specific travel history and your current immigration situation. In 2026, United States Citizenship and Immigration Services, working in direct coordination with Customs and Border Protection and the Department of Homeland Security, substantially expanded the framework through which international travel history is now being cross-referenced against open immigration case files. This is not an entirely new legal concept, and that point deserves to be stated clearly. The Immigration and Nationality Act has always granted immigration officers broad discretionary authority to evaluate an applicant's demonstrated ties to the United States versus their demonstrated ties to a foreign country. What is genuinely new in 2026 is the degree of automated data cross-referencing, the speed at which travel pattern analysis is being conducted, and the specific behaviors that are now triggering elevated scrutiny in ways that were not operationally possible even 3 years ago. We are talking about entry and exit records, passport stamp analysis, duration calculations, destination country flags, and the way all of that data is now being fed directly into immigration adjudication systems before an officer ever opens your physical file. Error is the fundamental misunderstanding that is quietly damaging immigration cases across this country right now. Most immigrants believe that as long as they maintained their green card, obtained a re-entry permit when required, and returned before their authorized period expired, their travel history is completely clean and completely safe. That belief is dangerously incomplete. And the next several minutes are going to explain precisely and specifically why. Under current USCIS adjudication policy, travel is not evaluated simply as present or absent. It is evaluated as a pattern. The frequency of your trips, the duration of each absence, the countries you visited, the timing of those trips relative to your application dates, and the consistency between your declared purpose and your actual behavior abroad all feed into a single critical determination. That determination is called abandonment. And in 2026, abandonment findings are being issued at a rate that immigration attorneys across the country are describing as genuinely alarming. Under the Immigration and Nationality Act, specifically INA, Section 101A-13, a lawful permanent resident is considered to have abandoned their resident status if the totality of evidence suggests their primary intention was to reside outside the United States permanently. Here is where most people make their most costly mistake. They believe the rule is simple. Stay outside the United States for less than 6 months and you are safe. Stay outside for less than 1 year with a re-entry permit and you are protected. That understanding is critically and dangerously incomplete. CBP officers and USCIS adjudicators are trained to look beyond single trip durations. If you took 4 trips in 18 months, each one just under 6 months, that cumulative pattern can and does trigger an abandonment inquiry, regardless of the fact that no single individual trip crossed any threshold. Beginning in late 2025 and accelerating dramatically through 2026, DHS implemented upgraded entry and exit tracking systems that now capture and permanently retain granular international travel data for every individual with an open immigration matter, including pending green card applications, naturalization petitions, and visa renewals. That data is now being automatically analyzed before your application ever reaches a human adjudicator. Red flags are being generated algorithmically, and those flags are following your file through every stage of the immigration process. Let me make this real for you with a concrete example, because this cannot remain abstract. Consider someone like Sofia. She is a lawful permanent resident who received her green card 4 years ago through her employer. She works as a registered nurse in Florida, earning approximately $67,000 per year. She is the primary financial support for her elderly parents living in the Philippines. Sofia traveled back to Manila 3 times over a period of 20 months. The first trip was 41 days to care for her father after a stroke. The second trip was 58 days when her father's condition worsened and required surgery. The third trip was 39 days for his funeral and to help her mother stabilize. Sofia never stayed outside the United States for more than 60 days on any single trip. She never exceeded any published threshold. She returned each time with documentation of her father's medical condition. She paid her taxes every year. She never missed a day of work she was not authorized to miss. But when Sofia filed her N-400 naturalization application, the automated travel analysis flagged her cumulative absence pattern. A formal request for evidence was issued questioning her continuous residence and her intent to permanently reside in the United States. Sofia's application is now delayed by more than 14 months. She has spent over $6,000 in additional legal fees responding to federal inquiries she never anticipated and was never warned to prepare for. The trips she took to hold her dying father's hand are now being used to question whether America is truly her home. Now consider someone in a different but equally serious situation. Think about a man named Tariq. Tariq came to the United States from Pakistan on an F1 student visa, completed his master's degree in computer engineering, transitioned to OPT, then H-1B status, and recently had his green card application filed by his employer. His priority date is current. His approval should be straightforward. Over the past 2 years, Tariq traveled back to Lahore 4 times, once for his brother's wedding, once when his mother was hospitalized, once during a company-approved remote work period, and once simply because he had not seen his family in over a year and genuinely needed to go home. Each of those trips was individually unremarkable. Each one was under 90 days. Each one had a clear and legitimate purpose. But the cumulative record showed Tariq spent nearly 7 months outside the United States across those 4 trips within a 26-month window. During his adjustment of status interview, the officer spent 40 minutes focused almost entirely on his travel history. His application was not approved at the interview. It was placed under administrative processing. Tariq has now been waiting 9 additional months with no update and no clear resolution timeline. His immigration attorney fees have exceeded $8,500 beyond the original retainer. His employer is questioning whether to continue sponsoring his case. And Tariq is living with a level of daily uncertainty that is affecting his health, his relationships, and his ability to perform at work. These are not isolated horror stories invented to provoke anxiety. Immigration attorneys in New York, Texas, California, Illinois, and Florida are all reporting the same pattern emerging with striking consistency throughout 2026. Cases involving travel-based abandonment inquiries, continuous residence challenges, and intent-to-reside determinations are appearing in their practices at significantly higher rates than at any point in the previous 5 years. The combination of upgraded exit tracking technology, expanded interagency data sharing, and specific enforcement guidance directing adjudicators to scrutinize travel patterns more aggressively has created a fundamentally different evaluation environment than what existed even 18 months ago. And that is precisely why this video exists and why you need to finish watching it. Now, here is the single piece of information that the vast majority of immigrants with travel history do not know, and that immigration attorneys say is responsible for more preventable case damage than almost any other misunderstanding. The 6-month rule is not a protection. It is a presumption. And there is an enormous and consequential legal difference between those two things. Staying outside the United States for less than 6 months does not automatically protect your green card. It simply means CBP cannot presume abandonment without additional evidence. But if other factors exist, frequent trips, strong foreign ties, property ownership abroad, foreign employment, or children enrolled in foreign schools, abandonment can be found even for absences of 60, 40, or even 30 days. And here is the number that almost nobody knows. Under current USCIS continuous residence guidelines for naturalization purposes, any single trip outside the United States lasting more than 6 months but less than 1 year creates a rebuttable presumption that you have broken continuous residence. Any trip over 1 year breaks it automatically. But multiple shorter trips that collectively disrupt your physical presence calculation can disqualify you from naturalization eligibility without a single trip ever crossing the 6-month line. Read that again. Multiple short trips, no single one over 6 months, and you can still lose your naturalization eligibility entirely. Here is another critical reality that people routinely misunderstand when they first encounter these rules. They assume that because their travel was innocent and their intentions were pure, the immigration system will recognize that and treat them accordingly. Immigration law does not function the way criminal law does. In criminal court, you are presumed innocent until the government proves otherwise beyond a reasonable doubt. In immigration proceedings, the burden operates fundamentally differently. Under INA Sections 245 and 316, governing adjustment of status and naturalization, the applicant carries the burden of affirmatively demonstrating eligibility. That means you must prove your intent to reside permanently in the United States. You must prove your continuous residence was not interrupted. You must prove your ties to America are stronger than your ties abroad. If your travel history raises questions in the mind of an adjudicating officer, you are responsible for answering every single one of those questions with documentary evidence. That process costs money, it takes months, and it produces a level of stress that ripples through entire families in ways that are genuinely difficult to describe. Now, here is something that matters even if you currently have no active immigration application and no immediate plans to file one. Every international trip you have taken since receiving your green card or your visa is permanently recorded in federal databases. Those records do not expire. They do not disappear after a certain number of years. They do not become irrelevant simply because time has passed. If you apply for naturalization 5 years from now, if you petition to bring a family member to the United States, if you apply for a travel document, or if you become the subject of any immigration review or hearing for any reason, your complete international travel history going back to the beginning of your immigration record will be accessed and examined in full. The record you are building with every trip you take today is the record that will either support or complicate every immigration matter you ever face in the future. Now, let us be specific about what has actually changed in the regulatory and enforcement landscape leading into 2026, because this is not simply about old rules being applied more aggressively. In late 2025, DHS completed the nationwide rollout of an upgraded biometric entry and exit tracking system that now captures departure data at all major international airports and land border crossings. Previously, exit data was inconsistently collected. That gap no longer exists. Simultaneously, the updated data sharing agreement between CBP, USCIS, and the State Department now allows travel records to be automatically integrated into immigration case management systems in near real time. An officer reviewing your naturalization application in 2026 sees your complete travel timeline populated automatically before the interview begins. Internal USCIS adjudication guidance, updated in early 2026, specifically directs officers to apply heightened scrutiny to applicants whose travel patterns show visits to their country of origin exceeding a cumulative threshold even when no individual trip crosses the published limits. As of the time this video is being recorded, there are active legal challenges in federal court arguing that aspects of the expanded exit tracking system and the updated data sharing arrangements raise serious Fourth Amendment concerns. Those challenges are being heard. Their outcome is genuinely uncertain. But until a federal court issues a restricting order, this system is fully operational. It is running today. And your decisions need to be based on the enforcement environment that currently exists, not the one that might exist after litigation concludes. We also need to talk directly about which communities carry the greatest statistical exposure to travel-based immigration scrutiny because the risk is not evenly distributed. Immigrants from Mexico, El Salvador, Guatemala, Honduras, India, Pakistan, Bangladesh, the Philippines, Nigeria, Ghana, Egypt, and across the Middle East collectively represent the communities with the highest rates of regular international travel back to countries of origin. These are communities defined by profound family loyalty, by obligations to aging parents, by attendance at weddings and funerals and religious celebrations that cannot simply be skipped, by the kind of deep cultural and familial connection that makes the idea of never going home feel like a form of slow erasure. That love is not a legal vulnerability, but without proper documentation and strategic travel